That case about the Colorado baker who refused to make a wedding cake for a gay couple is finally reaching the Supreme Court this week, and activists already began lining up outside the court last night. Back in 2012, Charlie Craig and David Mullins attempted to buy a wedding cake at Masterpiece Cake Shop in Lakewood, Colorado, but the evangelical Christian owner, Jack Phillips, refused. The Colorado Civil Rights Commission found Phillips liable for sexual orientation discrimination, which is prohibited by the state's public accommodations law. And state courts have upheld the commission's decision. But the Supreme Court is looking at Phillips' case because of free speech claims. He contains, the baker, that he was not discriminating on the basis of sexual orientation, but on the basis of a particular message, endorsement of same-sex marriage. Does he have a case? Joining me now is John Corvino. He's a professor of philosophy at Wayne State University. He's also the co-author of the book, Debating Religious Liberty and Discrimination. Professor, as you have written, this is actually the story of two cakes. It's the tale of two cakes or two bakeries. You've got Masterpiece in Lakewood, Colorado, where baker Jack Phillips refuses to sell a same-sex couple a wedding cake, and the State Civil Rights Commission said, well, that's discrimination. But at the Azakar Bakery in Denver, Marjorie Silver won't put a red X on a Bible-shaped cake with two grooms, and the commission says, well, that's okay. Isn't there an inconsistency there, and how do you resolve it?
I don't think there's an inconsistency. And of course, this is actually many cakes, because there have been a number of cases across the country about this issue. But I think the important difference between the two cases you mentioned is that one is a design-based refusal and one is a user-based refusal. And if I could back up just a second, the government gives businesses wide latitude to decide what they're going to sell. So we don't say that a vegan bakery has to sell a real buttercream cake, or that a kosher bakery has to sell a cake topped with candied bacon, or anything like that. By contrast, we don't allow businesses to decide to whom they sell. We say if you open a business to the public, it should be open to the entire public. And specifically, Colorado prohibits discrimination on the basis of race, ethnicity, religion, sex, and also sexual orientation. Jack Phillips, the baker in this case, would not sell the same-sex couple the very same items that he's willing to sell to different sex couples. That's different from Marjorie Silva, who said, look, I'm not going to sell this particular design to anybody. It's a design-based objection in her case.
So Jack would say, wait, it's not about who they are, it's about what they wanted. I, for example, if I'm that baker, I don't open on Sundays. I will not sell you, Professor, a Halloween cake because that does not comport with my religious view of the world. Does that wash?
I don't think it washes, because a gay wedding cake isn't really a thing. Gay people, we order our wedding cakes from the same catalogs that other people order their wedding cakes from. You pick your frosting, you pick your filling, you pick your cake flavor, you pick how many tiers you want. And Jack Phillips did not discuss any elements of design with the couple. He said, I will not sell you any wedding cake. And it's interesting, Masterpiece Cake Shop, his bakery, also at one point refused a cupcake order from lesbians when they found out that they were going to use it to celebrate their commitment ceremony. So this is a case where the use-based distinction and the user-based distinction kind of collapse into each other. It's not a specific design, again, that he's, like a Halloween cake that he's unwilling to sell. He's unwilling to sell this to same-sex couples at all.
Okay, what if they'd come in and they said, we want a wedding cake with two grooms on the top of it, and he said, well, I'll sell you the cake, but I am not putting the two grooms on top. Would that have been a stronger case?
I think that would have been a much stronger case, but that's not the case that the Supreme Court has before it this coming week. He would not sell them any wedding cake at all, wouldn't even discuss designs with them.
Professor, are we about to establish policy that will apply not only to the baker, but also to the florist, to the calligrapher, maybe to the wedding band? Your band gets hired and you say, oh, we don't want to play a wedding dance at a same-sex couple. Will the Supreme Court be able to articulate something that will apply to each of these circumstances?
I suspect the Supreme Court will try to rule on this case in a way that's very narrow, that does not have implications for all of those other cases, because in some of those cases we're talking about something a little bit different. Photography has traditionally been recognized as an art form more than cake baking has. The wedding band, when different artists perform on site at different events, that's a little bit different from the baker who sells them something and then they take it away, and the baker, what they do afterwards is none of the baker's business. But I do think that this case has important implications for whether religious freedom or the freedom of speech give people a license to discriminate. And I think it's really important that even though this is about cakes, anti-discrimination law is not primarily about cakes and flowers and other frills. It's about employment, it's about housing, it's about basic goods and services. And I think it's really important for the court to say, you know, when you open a business to the public, you open it to the entire public. You don't discriminate on the basis of these characteristics.
Quick final question, Professor Corvino, and thank you for being here. Once again, is it Justice Kennedy?
I think Justice Kennedy is important in this case, but I also think that you might look at some of the other justices. I think even Justice Roberts could rule with the state of Colorado in this case against the Baker, because again, if you look at the history of precedents on cases like this, freedom of speech, freedom of religion does not ever give businesses the right to discriminate on the basis of these protected characteristics. You know, a get out of the law free card when it comes to anti-discrimination law. And I think it's really important for the court to establish that.
Amazing that they're already lining up on this Saturday for this Tuesday argument about the cake, obviously because it's about much more than just the cake. Thanks, Professor. I appreciate you being here.